the advocate on record, in bracket, who is not before us when the matter is called on.
But she's held up in another court.
So we are recording that only.
Let's not say that.
Notice to other participants.
Accept notice on behalf of the See, because we are doing it in the morning only, somebody said that 8 learned advocates missed out.
Right.
And for some reason, if this order is to be recalled, she will say that I wasn't present in court. My name has wrongly appeared.
No, Lordship, not in this case at least.
No, we don't know. We have to formulate some. If somebody doesn't appear, on what basis can we record the appearance? So you were holding accept notice.
Great.
Leave of respondent number 3. Hence, formal service of notice on respondent number 3 is dispensable.
Obligation.
Notice issued to parent. Notice issued.
Item 20, my lord, in an election matter where SDM directed for recounting, my lord, I've been declared as a winner. Now, my lord, High Court in an interim order granted a stay. Now, thereafter, matter is not being taken up, my lord. There is no.
Go to the High Court.
Lord, may I only point out, we did mention the matter twice.
I mentioned there.
Lord, may only see the cost status, my lord, which I have annexed the.
Whatever, we are not interfering.
Milord, may only say with leave to approach the High Court, Milord,
that you have.
Milord, it's not, Milord, we have moved that.
As the matter, as the petitioner has come at the interim stage only, and the main matter is pending before the High Court.
Milord, may only say that the petitioner be requested to make a similar prayer before the High Court. Though I have that right, but Milord, my IA for early hearing is also being not taken up, Milord.
We are not.
Milord, it will leave, Milord, I being democratically elected, Milord. My tenure will be over. By that time, this writ petition will be decided, Milord.
High Court is also a constitutional court. It has applied.
Milord, but
and
Milord will see 7 days. No order sheet passed by the High Court, Milord.
But go before the High Court, take whatever measure. Yes, next matter.
Milord, may please give me that liberty. Can I request, Milord? This
you have that liberty. It's a pending matter.
It's already a pending matter.
You apply. Yes, next matter.
This is item number.
It's item 21. I appear for the petitioner.
22.
21.
21.
Sorry, sir. Who in my submission has no jurisdiction, no authority. Other than this report, there is no material placed by the complainant against me to establish my encroachment. My encroachment is not reflected in the encroachment register of the village either. Now, I will candidly admit that the mistake committed by the petitioner is that during the pendency of the proceedings before the learned collector, the petitioner demolished the purported encroachment, although the petitioner, I'll point out. Because the consistent case of the petitioner is that this is not encroachment. He was ill-advised. I can't run away from it. Would your lordship I'm an elected representative. Please give me some time. Would your lordships kindly see the report prepared by the Talati at page?
You have yourself demolished.
No, but with greatest respect, the complainant's case cannot depend upon my conduct.
No.
In fact, would your lordship
your cases, your conduct will determine that.
It's not.
Dismissed.
Just a moment. Would your lordships kindly see the factual finding?
You have no case.
Please, just for a moment, just one report and I leave it at that. There is a factual finding in my favor that the encroachment does not exist.
Because we have demolished it.
No, prior to that, with greatest respect, prior to that. Would your lordship just see that? That is a mistake that has been committed. I can't run away from that. In fact, I just...
How can a person demolish a house?
Your lordships are right, but there are two things in my favor. Let me just point that out and then I leave it at that. Number one, pursuant to the collector's order, there is a report which has been prepared by the Talati and the circle officer where they categorically record.
Your own conduct is showing something. Yes, next.
The entire case is on the basis of assumptions, Milords. And your lordships have upheld a decision of the Honorable Bombay High Court where it has held that such disqualification proceedings cannot be decided on the basis of assumptions. Your lordships order.
You have yourself acted like that.
Who
Yes.
have done it?
No, my lords, your lordships are right.
Next matter.
Lords,
Yes.
Very,
As
I'm
item
obliged.
22 and 23, I'm seeking a passover on behalf of Mr. Rohan. He is on his legs in court 1.
Very well. We'll wait.
Passover, normally we are,
Well, my problem is, after your lordship's considered view in chambers and otherwise, that the custody must be with me. This is the worst kind of imaginative excuse by the father to take the child. The father says three things. Well, I'll take 30 seconds. One, child is with them. Child is not with me, so delay helps them.
Mr. Rohan
we
will be here.
will take it next Monday.
Well, every delay, of course, hurts me, so lordship will take it next Monday.
Yeah,
Monday.
next month.
Next Monday.
Accommodation is asked for on behalf of,
Well, there's no
The
petition
alleged-
respondent here. Just take the name of the father, because there are both sides have filed IA.
accommodation is asked for on behalf of
Father.
Lakshnath
Yes, your lordship.
Lakshnath
Talwar.
Talwar.
Lordship. Let's kindly consider one thing. The child is with them. His school is suffering. The person takes him on the ground that, well, I am going away, running away to Dubai prospectively. When I make an email communication saying I'm going to Dubai for a vacation, he uses an excuse.
If we find there's a breach
Like
of,
Mr. Rohan, he will be here even if the matter is passed over for 15 or 15.
we can't
No, my lords.
All right, your lordship.
midway
All right, your lordship.
Like next Monday.
Monday.
Monday. If the matter is so important, then we are not dismissing or passing ex parte orders. 20.
Please, your lordship. Prove me, Lord, this is against the interim order. But before dissolution of the Gram Panchayat, I was working as a Sarpanch. I am a democratically elected as Sarpanch.
Sorry.
I kindly appreciate. So 8 members resigned, so that fault cannot be attributed to me.
Only interim order.
Lordship may kindly indicate that High Court may decide it within a 3 months at
No,
least.
no.
Otherwise, my tenure will get over.
Approach
Because
the
there is
High
no,
Court.
no fault can be attributed with me. Election Commission issued a notice for the election.
You are
Within a
inventing
6
an
days.
Article 227 for us. Yes.
And do that.
Next matter.
For the petitioner. My lords, here two main principles of law the High Court ignored. One is, my lords, best interest of the child. Children are with the mother in the presence of her brother who is accused and has an FIR and charge sheet under POCSO. My lords, the children are in their presence and visitation and access to the father from March 23 is not given. And my lords, second issue is, my lords, at least till then, my
No,
lords,
no.
maybe issuing notice.
No, no.
Please let me see the children for a visitation, only till the next date.
Notice.
My lords, the hearings are, my lords, just till notice is issued.
Sorry.
Then, my lords, at least since the matter is also pending in the family court, at least stay till then, my lords.
No.
Should not,
No,
You,
let it
you
go.
apprise the family court of this notice, let the family court take a call.
but at least the maintenance then may be stayed, no application
No,
for
no,
maintenance.
you are not
may-
saying anything.
Nothing, we are not staying in.
And at least access to the children, my lords.
Pay
Till
the wife, the children are there with her.
My lord, since March, the father has not seen.
Anyway, we should notice. Yes,
Some
next
date will
matter.
be given, my lord, some
Date will come.
a short date, my lords, 1 or 2 weeks dates, my lords, next week, because I'm deprived of access to my children, my lord.
Why do you fight so much?
I'm sorry, my lords, any short date. My lords.
If you're so concerned with your child,
The anxiety of a father, my lords, since March, he's not had access to his children.
child is with the mother only. It's not,
My lords, they live, my lords,
not a
they
missing
don't.
child or.
My lord's child may be with the mother, but the children are in the vicinity of someone who has been accused of sexually assaulting his own daughter, my lords. That is the risk.
Okay, we'll see.
Yes.
That is the allegation. Next matter.
My lord, some short date, my lords. I'll any with Dusty.
Who is the-
Dusty.
I appear for the petition.
Great.
Eviction on the ground of,
to respond more.
but eviction on the ground of bona fide requirement. Only one point I'll make and leave it at that. But there are 6 rooms in the building. I was occupying room number 4. After the suit was filed, the requirement had come to an end. That is our case. That because wife or in the room was claimed had expired.
Purely
And one flat, room number
actual-
5, had become vacant.
Concurrent
But-
findings are there.
Concurrent finding by all courts. But may I only request one thing? We already booked a flat somewhere else for the purpose of finding accommodation.
You already have that accommodation.
No, we don't have residential accommodation. I have purchased a flat, some time may be granted, but some time may be granted. Below, I am seeing nothing else. We'll move out, some time may be granted. What?
not necessary.
Lord, some time may be granted, my lord. Usually, the this court grants some time. to vacate.
But that's why we are.
Lord, we have already booked the flat. We'll be moving in that flat in a while, my lord. No difficulty about that. The building is near completion. I'm only seeking some time, some indulgence from the court. Unusual undertaking.
If it goes for execution, you ask
No,
before
on
execution court.
but we had given undertaking in the High Court.
As in any
That undertaking comes to an end today.
You've
I'm
given
seeking
an
some
undertaking.
time. I can't
case,
come
it
back.
can't be.
No.
I can't come back to this court. I can't go back to that court. I'll have to take some extension from this
Given
court.
an undertaking, live by it. Yes.
Lord,
next
I'll
matter.
have to seek some extension from this court. Lord, I can't go back to High Court for that.
Sorry.
But some extension, maybe up to some 31st March or whatever that may be. Whatever court feels proper. I'm not even bargaining on that.
No, you are bargaining from
Lord, I'm only seeing some
the
extension.
starting of the matter.
I did not even start the matter. I did not even bargain on or start the matter on merits in that sense, my lord. Some accommodation from the court.
No.
Usually-
You have given an undertaking, follow it.
But
Yes.
that's
Next
usual,
matter.
my lord, in these matters, my lord. That's not unusual in this.
We are not giving it, please.
But some extension,
No,
please, my lord.
letter.
Article 28, visitation rights have been given to the father for 5 out of 7 days. All I seek is some balance. All I seek is some balance.
Is deprived of it, just deprive this, because every day if the child go.
Notice.
I appear for the
That
respondent.
is your, my lords.
Because my learned friend is appearing on caveat, my lord. Mr. Rao is on screen.
I just wanted to point out why this order was passed, my lord. The
Okay,
petitioner.
just pass. We should
Yes,
notice.
We should
Nothing.
notice only.
All right, my lord, all right.
They have
File a reply, my
filed a reply
lord.
last night and served upon me. Would my lords
File a
have it
reply,
after a
my
week?
Obliged.
Jump for notice. Returnable 2 weeks hence.
Okay. They already served.
Presence can be.
Acha. Returnable 2 weeks hence as the respondent appears on caveat.
Please, my lords.
On caveat and accepts notice on behalf of his client. Formal service of notice, hence is dispensed with. Yes.
Obliged.
Obliged, my lord.
$30. Who is appearing? Anyone on?
In this case, the grounds of some other SLP has been put. Just see the ground.
You dismiss me. None appears. For the petitioner, when the matter is called on, adjourned for 3 weeks.
On the table.
Please, your lordship. It's in item 31, my lords.
Just one.
Yes.
My lords, in item number 31, my lords. My lords, the petitioner was a witness in the FIR. There was no specific availment made against.
Washing has been denied.
This my lord.
Why not?
Well, we are seeking entry protection, my lords.
No. Dismiss. 482 washing denied. What will do?
May I please ask? Total 7 prosecution witnesses have been examined. None has seen that the deceased was conscious. But PW1 and PW2 were the.
No, this so-called dying declaration is made before whom?
It was before the IUM, Lord.
It is before the doctor.
Doctor.
No, doctor was present. But
So before the
Yes,
doctor,
it is
I
before the doctor has.
the doctor was present, but he has not signed the document. But
not necessary.
in fact, none.
If he has deposed,
Not, But the condition was not page 79 maybe.
That's again your question of fact. There's a impartial person.
No concern whatsoever.
Not page 39.
He's
PW
not an interested party. He is deposed. Why should we doubt? Dismissed.
not 12 years incarceration. Lord.
When remission you apply whenever time comes.
Another 2 years and then remission you can apply.
Please, my lords. Lordship, the allegation,
482 is rejected. What is there to interfere?
my lord, I have one submission. The allegations are against us, which are beyond our job profile. Acquittal order has been passed against in our favor, my lord. Despite that, I have been not named in the FIR, my lord. About 100% are there.
482 case.
My lord,
dismissed.
My lord, the allegations are against our job profile, are beyond our job profile, my lord.
482, you'll have enough chance at many stages to question.
I'm Rahul Saini in person.
Okay.
Child custody matter.
You are?
I'm Rahul Saini.
Okay.
Birthday Donisa Saini. My child.
No, whose petition is this?
By
34.
In person.
in person. Could challenge the amendment
Yes, sir.
in a criminal writ petition.
Yes, sir.
How is it?
Donations.
So basically, in this case,
Just one.
Rahul Saini. In person,
So Rahul Saini on whom?
No, this is not Rahul Saini.
Donisha.
Donisha Saini.
Donisa Saini is my daughter.
He's on behalf of.
Oh, okay.
How can you?
I'm Rahul Saini, petitioner number 2.
No, but how did you make her a party? She is with the mother.
Sir, because this I have filed domestic violence because child has emotional abuse. That's why I filed
Domestic violence by you.
child emotional abuse. Child
No.
responded to. That's why I filed because emotional abuse.
Domestic violence would not lie. Some other.
Whatever provision it would be, that's a different aspect, but not domestic violence.
So why you
Can't
not,
misuse the
why I
process.
don't know why you not consider because if we check the some other countries domestic violence emotional abuse covered in domestic violence act, but in India domestic violence not covered in.
Kindly, new parliament house is there. You have to take it there. Dismissed. We can't decide why a statute is framed in a particular way. Yes.
So please liberty for High Court for revision for this.
Whatever you have,
You avail of your remedy which is available to you.
Sir, please in the order you have mentioned.
No. This is not the way it should be framed. Yes. Next matter.
Yes, Lordship, the petitioner is behind the bar, my lord, for last 1 year, and the bail application has been dismissed the High Court, my lord, without considering the 164 statement and the medical report, my lord, and CFSL report. And my lord, as far as the 164 statement is concerned, my lord.
Yes.
Yes.
What is it?
My lord, the charges is under section 363, 3762N.
No, 164, what do you want to rely on?
My lord, my lord, the
interfere, dismissed.
my lord, may I permit, my lord?
No. Yes.
My lord,
Next
my lord,
matter.
my lord, kindly, issue direction to expedite the, my lord, the trial court proceeding.
You have.
I'm requesting, my lord.
Dismissed.
See page 37 for a minute.
What is happening It's a procedural matter.
Kindly see page 37 for a minute. So many opportunities being costs imposed, still it is cost.
So you didn't cross-examine earlier, why?
That's why I want to.
Why should you interfere?
I just want to show page 30.
Let us see what the point of law you have taken.
That's precise, just 30, page 37.
No, what point of law you are relying on?
No, I am only relying.
Let us see page
Let's
18.
see the point of law. Yes.
What
How
is
is
the
it
point?
can't be contrary to the statute? Yes. This is her complaint against her own parents. My family members are beating me every day.
No,
They
no,
don't
you
allow
take us-
me to go.
Question is
not that here.
Questions of law, what you have formulated?
I want to cross-examine her on these points only. The questionnaire, you can always put it, the court can do that. Is the procedure prescribed in the box?
She is not a minor.
She is not now a minor, but at the time of commission of the offence, she was a minor.
On the date of the filing of the FIR, she was not a minor. Now she's married somewhere else. I'm also married somewhere. My life will be ruined just because I am not allowed to cross-examine her.
Opportunities were given.
No opportunity was not given. I filed an application. They said you have filed an application at 4 o'clock, not in the morning. On that basis, the application has been dismissed. And my right to cross-examine
was very much there the whole day, but you didn't choose to do that.
and it has been closed. My cross.
Dismissed.
Item 37 has circulated a letter, my lord. Apparently, the letter was not on record, was circulated just a.
So,
Not clear.
what ground?
Not with personal difficulty for the arguing counsel, my lord, today.
Accommodation is asked for on behalf of the petitioners. This
Any date.
6 weeks.
May I please look. Look, the petitioner before your lordship today has undergone 21 years. Look, there have been favorable
But
reports.
why Article 32?
The reason is, the offence occurred in Tamil Nadu. Subsequently, I was transferred to Ujjain at my request because I am from there. Now the request is oscillating between the state of Tamil Nadu and state of Madhya Pradesh. That is what is happening.
Normally, where is incarceration?
That is it.
No. Where the, no?
Where the connection is there.
Where the
That's been
conviction?
settled, that has been settled. Wherever the conviction here, in that court. But is
There.
for the proceeding of the
Oh, it was in DBRAU. His conviction is there. And why didn't you take that? But what has been held?
No, he's not even decided, the matter is not.
That's
it is
32.
pending with the tribunal.
Okay, we issuing notice.
I'm obliged. Would your lordship make it returnable?
Returnable 4 weeks since.
I'm deeply obliged.
Yeah, this is the recovery of the cup syrup, your lordship. I mean, already custody.
How many?
150 bottles.
What were you doing? 115 bottles of cough syrup?
Your lordship, basically, it's a.
Are you a pharmacist?
No, your lordship, the 5 persons, and I'm already studying 1 year, 9 months, your lordship, in this matter. Your lordship is granting the bail. Your lordship may kindly see the order. May I pass your lordship? 11 matters I am coming across. Your lordship is giving the bail in the cup syrup.
See, each bail is.
Your lordship, your lordship may kindly consider. Can you pass this? Your lordship may
At
kindly.
what stage is the proceeding?
Your lordship, there is a matter, is a stage of the trial, no development, no development in the trial. Your lordship may kindly consider the order. Only out of.
We won't, because bail order.
Your lordship may kindly consider, then your lordship may kindly consider that.
We give an order which will be contrary to this 11.
Your lordship, this is a cup syrup, your lordship, in 100 ml, only 0.2 grams the
Okay, but whatever you do with
Your Lordship,
Did you have so much
Your Lordship,
staff?
they have planted the 5 persons, Your Lordship. So many people are coming across the only this kind of the.
See, you don't have a pharmacist license.
I was in the bus, the recovery is disputed, everything is disputed, and
Then
you are
that
out of the bill. Your Lordship, may kindly consider for 1 minute. Your Lordship, may kindly consider.
Dismiss.
Your Lordship, may kindly consider. Your Lordship, may kindly consider, please. Your Lordship, may I pass?
What is the ratio of this?
Your Lordship, the ratio only the cups on the period of incarceration.
No.
Only the period of. Your Lordship, may kindly appreciate for 1 minute. Your Lordship, I'm so sorry, Your Lordship. Your Lordship.
No.
And Your Lordship.
If you want, we'll pass it.
Your Lordship, out of 5%, 3 are out on the anticipatory bail.
If you want.
Your Lordship, may kindly say.
If you want us to give reason, we'll give reason.
Your Lordship, I can't say anything, Your Lordship, but out of 5, 2 are. Your Lordship, may kindly, Your Lordship, for my Your Lordship, may kindly consider. Your Lordship, may kindly consider. Can you move this? Your Lordship, may kindly consider this.
Order says 685 bottles.
Your Lordship, may kindly see the first is the 46 well, second 300 bottles.
Order indicates 685 bottles, which were recovered.
Out of
The order says
For 6, sir.
page 4.
Your Lordship. Your Lordship.
685 bottles.
For 6 people, Your Lordship.
So what is the joint possession?
They have shown the joint position, Your Lordship. Kindly see.
Then
Your Lordship, may kindly
Sorry,
see.
dismiss.
Your Lordship, may I permitted to withdraw and move the application before the trial court, Your Lordship.
Sorry. Next matter.
Your Lordship, may kindly withdraw, permitted me to withdraw, Your Lordship.
No, you. After so much argument to you.
Your Lordship, I have only made the request, not the argument, Your Lordship. I only tried to please, Your Lordship, may kindly permit to withdraw, Your Lordship.
After passing an order.
Your Lordship, may I request for the expeditious trial, Your Lordship?
That trial has commenced.
Your Lordship, may kindly say 1 year, 9 months, Your Lordship. The cup syrup, Your Lordship. The cup syrup, Your Lordship, may kindly
So what? Cup syrup? No one is having it for
0.2 mg in one bottle, Your Lordship. 0.2 mg codeine, Your Lordship.
Becomes a mixture. Under the NDP.
It's a medicine. It's a medicine, Your Lordship.
No. It's a mixture now.
Your Lordship, may kindly.
I had the occasion.
Your Lordship, may kindly say the expeditious trial, so Your Lordship, that I can.
correct. That's it.
Well, in this case, my right to a statutory appeal as against the decision of treating me as an adult when I was a child is been dismissed on the ground that the continuation of delay is not allowed.
How many days delay?
397 days.
Can
Well, the board says, if I may request a return of a date.
Truthful to the court in any case.
Malad?
Should be truthful to the court.
My lordship is right.
When you draft pleading, you need to be careful as to what you are putting there.
My lordship is right. My lord, but the psychologist obtained.
Anyway, yes, we should do this for now.
But an indulgence that if I may be permitted to serve on the State's Council, standing on.
you serve on whoever is to be served. Regular notice. Yes, next matter.
A returnable date, my lord, if I may request for it.
4 weeks.
My lord, if the trial could be stayed, my lord, because it's yet to be commenced.
Oh, no.
Obliged.
But here, my lord, I had come, my lord. Your lordship may kindly see page 7 of the application. I'm sorry, I'm standing on the respondent side. Page 7, my lord, of the application. Your lordship not granted me liberty not to approach the High Court for an early hearing. I filed the early hearing application within 10 days, and the date, my lord, is of December. It is beyond the date which was there originally. A part. B part, my lord, I completed my LLB while in custody 14 years, my lord. in custody. My exams are there, my lord, the 3rd of December, my lord. But today, my lord, I am in such a situation where, my lord, the state doesn't take a decision for the remission policy and the High Court doesn't hear me.
At least interim.
Both, my lord, I am in such a situation.
The exam.
Yeah, that's right, we can grant.
We'll take it up on Monday. You serve on the standing council.
Lord, I am in parole, my lord, till the 1st. If my parole, my lord, could be extended till
Not ex parte.
But then I have to surrender. 3rd is the exam. I won't have said, Lord, my statement can be recorded. I'm on parole, Lord, till the 1st. If it could be, Lord, till that benefit could be extended till, Lord, the 3rd.
That would be for the executive authority too.
So I'll have to go back to custody.
And second would be,
Huh?
Monday would be second.
30th. Let us keep it on 30th. Let service be affected on the standing council for the state of Gujarat. Who is the standing council?
I believe, Lord, Ms. Kadial, she is there. I know her.
Do it today only.
I'll do it today.
In course of the day only.
During the course of the day. Matter. Greatly obliged. Greatly.
Please, Madam. Madam has called for the report, Madam, from district in session judge, Madam, juvenility.
The petitioner had filed application under section 92 of the Juvenile Justice Act, and my lords had directed.
This has to be heard.
Yes,
This has to be heard.
Yes, ma'am.
But the
Hearing.
report has come that he is not a juvenile.
A copy of the report is not, sorry.
Let a copy of the juvenility report be given to
Council for the state.
Council for the state
Yes,
on hearing day. List on hearing day after 3 weeks.
Not a juvenile, 17 years old. This is of the birth certificate.
Sure. Yes.
Lordship, I have been deceived for keeping good faith. Kindly see, 24 lakh cash has been paid is said, but according to the partition deed, at page number 25, your Lordship may please see. If on that day, page number 25 may be seen. If on that day, if I was paid 24 lakh cash, no, true. No, 25, kindly peruse page number 25.
Let's see how you have framed your questions of law.
Yes, sir. Questions of law. Yes. Page number 14 may be seen.
A is all facts, not a single question of law.
True. The question here is, suppose page
Where you have stated.
Well, page D for you, your Lordship, page C may be seen. Whether the court
you was from the pleading where you have formulated the question of law on which you want.
True. First, I'll show.
No. You asked for that is the first thing.
Yes.
136 question of law is.
Yes, sir. Whether the courts below, page number 15, whether the courts below erred in dismissing the suit as the first Vermont had failed to discharge the burden of proof that he had paid the petitioner rupees 24 lakh in cash, which is against producing the account detail. The registered document. No, page number 25 may be seen also. If the registered document says that I have paid you by check, that's why I want to show. Page number 25 may be seen. If he said that he has paid by check, where is the question of him paying by cash later? With the fraud.
How did the trial court decide this?
They simply said it's a registered document. I can't go beyond that. If this is the way they said.
Where is the registered document saying paid by check? Where is the document?
Yes, page number 25 itself is a document, registered document. Kindly peruse page number 25 also. The third line says, thus, this is the deed. Thus, as the respective shares, a total 27 lakh is paid so on Karnataka Gramin Bank because everyone has accepted the same. If this is their registered document, how can there be cash payment by 24 lakh?
No, you have received this money.
No, that is why
Then how was it registered? Did you?
Lordship, this is my brother and sister, so with all the good faith, I went to this one that he will pay me. Lordship, when there is a good faith,
Party to this. You are a party to this.
No, page number 49 also. Sorry. Lordship, no cash has been paid. 24 lakh cash payments have been paid, Your Lordship.
Yes, next matter.
That's what. Suppose I am party to the deed, but if it is said that it will be paid by check, how
I don't know in which context, what facts.
That's Your Lordship, I am seeking one notice only. Let them come and say that how they paid 24 lakh.
No case. Next matter.
45, my lords, I beg for paper.
This is also a purely question of fact.
Well, it's
whether it's a joint HUF or not.
Joint family business or a partnership deed, my lords. Ultimately, my lords, what the High Court holds against me is that since I have filed a separate written statement and I have deposed also against the plaintiff, therefore I could not have changed my position in the appeal stage, which is completely contrary to what my lords have laid down. In a partition suit, my lords, the plaintiff and defendant can always change positions. It's all within the family.
No.
This is
change position. What? Preliminary decree stage or?
No, my lords, at the appeal stage also.
No.
That's what. At the
shares were determined.
The trial court, my lords, allows the suit. It passes the decree.
So then what is the contest? Shares are admitted.
No, my lords, shares are admitted in so far as, my lords, the plaintiff went, my lord, seeking a partition of the X property.
Oh, very good.
Yes, my lord.
Okay,
now, I understand.
1/10 share.
Yes, my lords.
Then normally whether it can be divided by meets and bounds.
That's not what I'm coming. There were a total of about 10 properties. Now he went in for a partition suit asking for a partition of all the properties. Now I was one of the defendants. I said that if at all there are only certain properties which are in the common pool, if at all there could be a share, it could be only in relation to those common properties, not in relation to the other properties. In fact, my lords contested the suit. When he actually, my lords,
when did what did the trial court hold?
The trial court actually decreased the suit. The trial court decreased the suit.
The 10 properties are.
In fact, it is in my favor also. The trial court, my lords, I am one of the defendants, it is in my favor. But when actually, my lords, the other side, the other defendant, takes the matter in appeal, first appeal to the High Court, the High Court reverses the decree, saying that it is not a joint family property at all. All these things are individual properties. This is a partnership business which is actually there. So far as the partnership is concerned, it has not been actually, my lords, the shares have been decided in terms of the partnership.
So who had contest?
Yes, that's where actually, my lords, I am one of the defendants. I am a brother.
Suit was for partition by a brother.
There are 3 brothers. So, one brother files a suit for partition against the other remaining 2 brothers.
Other purported co-shares.
Yes, my lords.
They contested the suit.
They contest all the
self-acquired properties and not a HUF.
Yes. Yes, my lord. Certain properties are HUF, certain properties are not. Okay. Ultimately, the trial court, my lords, decrees the suit in favor of the plaintiff. Now, one of the defendants, my lords, who actually loses, he actually files an appeal. At that point of time, he joins me also as an appellant. Whereas actually, my lords, during the course of the appeal, I have a change of heart because after all, it is within the family. So therefore, my lords, he moves an application for replication and he says that the first defendant, he says that, look, I am going to actually, in fact, have a clash of interest with him. So therefore, let it may be transposed as one of the defendants. Now, that is accepted on his application. Now, the High Court holds this against me, saying that once you have filed a written statement and once you have laid evidence to show that actually, my lords, you are opposing the suit, now you cannot turn around and say that now, no, I am with the plaintiff and therefore actually your claim cannot be entertained. That's how I am, my lords. But today, my lords, the position is right. That's what the High Court holds, my lords. Kindly have, my lords.
Yeah, that's right.
Yes, my lords. Kindly have, my lords. Of course, on the first issue, the High Court says that it's not a joint family, it's a partnership deed.
Correct.
But so far as the other issue, kindly have page 24, para 25. Page 24, para 25. The answer to the question is whether the turncoat stand of the second defendant transposed as 14th respondent in the appeal suit proceedings will change the factual or legal positions. The second respondent, that's the second defendant, that's I am, transposed as 14th respondent in the suit has filed the written statement before the courts below. It is pleaded that from items 3 and 4 as his absolute property, and he purchased the same out of his own income, and he has been enjoying the property as an absolute owner. He deposed before the courts below on the same line, so he prepared the present appeal, suit number so and so, along with the present appellant. Now he has taken a contrary stand as per order 41 read with section 96 without proper.
Stated on both. Sorry, Mr. Balasubramanian. Dismissing.
My lord, sir.
Dismissed.
My lord, I leave it at that. Obliged.
This application is for a clarification of your lordship's judgment regarding that B.Ed, DLEd matter, which your lordship had decided in the context of Rajasthan teachers. But now there were a large number of teachers, for example, my lord, here.
So this is where I was a party.
Yes.
Even West Bengal matters were.
Maybe Mr. Bhushana.
Dhulia also.
Yes, Justice Dhulia.
It might be better if your lordship listens.
Or at least it goes to his lordship because his lordship is the author of the judgment.
Yes, yes. So what I am requesting is, there are 3 matters which are pending in this court which involve the same issue from different states. Your lordship may have them all listed on some date before a bench of your lordship and Justice Dhulia. That would be the most appropriate thing for them.
Lordship, may I make a submission? Lordship, may I make a submission in this regard?
Yes.
This is not a, this is an appeal arising out of the.
We are seeking, initially right now, we are applying before the Honorable Chief Justice for
Constitution of.
We have our objections to this application.
Okay, on merit we'll see.
Merit is a different aspect.
In this proceeding, the applicant seeks certain clarification of a judgment delivered by
11th August 23.
2-judge bench of this court, comprising of the Honorable Justice Sudhanshu Dhulia and one of us in bracket, Aniruddha was J. So, the judgment was authored by
Justice Dhulia.
Honorable Justice Sudhanshu Dhulia. Stop. For proper appreciation of the present application, in our opinion, the matter could be, the matter may be listed before a bench comprise of same 2 honorable judges, so, subject to direction by the Honorable Chief Justice of India. Let the file be placed before.
Actually, it would be appropriate if both your lordships.
That's what lordship was. That's what lordship.
Exactly what I was.
That's exactly what lordship.
I am okay.
Right.
May I please, my lords? My lords, I'm sorry I'm not appearing physically. I broke my ankle. My lords, this is a petition whereby the petitioner is seeking suspension of his sentence. My lords, he has already undergone more than 8 years, 3 months. And with remission, he has undergone 11 years, my lords. This appeal has been pending since 2017.
Yes, dismissed.
My lords, let me just say 2 points, my lords. My lords, I have been convicted solely on the basis that I've